The purpose of the Flick-Reedy Education Enterprises is to promote individual moral responsibility through education. How do we do this? We study and discuss the interrelationships of history, philosophy, social studies, and economics. We do not dictate. We do not make statements as to what we think you should or should not do. We do not unduly burden this program with footnotes, references, or complete documentation. However, we do give sufficient data to bring this discussion into proper focus. We invite you to delve further into the necessary historical and statistical data to develop a deeper understanding of truth and a keener sense of individual moral responsibility.
As the Constitution was made known to the public for ratification, loud cries arose from many sides. Some said, "You have not given the central government enough power." Others cried just as loudly, "You have given the central government too much power. You have proposed another form of servitude." To answer the critics from both sides, several of the convention delegates wrote articles which appeared in the newspapers of the day, explaining what was meant by the written words of the Constitution. Best known of these is a series of essays written by James Madison, a states' rights man from Virginia, Alexander Hamilton, a strong central government advocate from New York, and John Jay, later to become the first Chief Justice of the Supreme Court. Some 85 essays of theirs have been collected today into one book titled The Federalist Papers. This book of essays is the most accurate reference for determining exactly what the convention delegates meant by the sentences in the Constitution. No home, no school, no library should fail to include several copies of this inexpensive reference book on its shelves. To examine the intent of the convention in giving power to the Congress in Article 1, Section 8, we shall review a part of essay number 41 by James Madison. But first, why did Madison write essay number 41? Perhaps a person had argued in a newspaper column, something like letters to the editor, that the convention had lost its head in giving too much power to the federal government. The critic said,
"The power to lay and collect taxes, to pay the debts, provide for the common defense and general welfare of the United States, amounts to an unlimited commission to exercise every power which may be alleged to be necessary for the common defense or general welfare."
Madison replied,
"Had no other enumeration or definition of the powers of Congress been found in the Constitution than the general expression just cited, the authors of the objection might have had some color for it, though it would have been difficult to find a reason for so awkward a form of describing an authority to legislate in all possible cases."
Madison continued,
"But what color can the objection have when a specification of the objects alluded to by these general terms immediately follows, and is not even separated by a longer pause than a semicolon? If the different parts of the same instrument ought to be so expounded as to give meaning to every part which will bear it, shall one part of the same sentence be excluded altogether from a share in the meaning? And shall the more doubtful and indefinite terms be retained in their full extent, and the clear and precise expressions be denied any signification whatsoever? For what purpose could the enumeration of particular powers be inserted, if these and all other were meant to be included in the preceding general power? Nothing is more natural nor common than first to use a general phrase, and then to explain and qualify it by a recital of particulars."
At this point, Mr. Madison gets a bit nasty, just as people do in letters to the editor columns once in a while. Madison continued,
"But the idea of an enumeration of particulars, which neither explain nor qualify the general meaning, and can have no other effect than to confound and mislead, is an absurdity, which we are reduced to charging on the authors of the objection."
And after further showing the author of the objection in a bad and illogical light, Madison cuts him to pieces with his concluding statement.
how difficult it is for error to escape its own condemnation.
The primary purpose of sharing the foregoing quotation with you is to demonstrate that it was not the intent of the Founding Fathers to have written a blank check for the Congress, but to have nailed down tightly the exact nature of its powers. Now, I believe that you will read Article 1, Section 8 of the Constitution with renewed understanding. Madison and his colleagues were successful in dispelling the fears of the people of their time about Congress using the terms common defense and general welfare as a reason for legislating in a wide variety of areas. But ask yourself, how well have we, the people, restricted Congresses of recent years to the intent of the Constitution? You may have heard it said that the U.S. Constitution is too old to have meaning today, that it was written almost 200 years ago for what was primarily an agricultural society. I can see by your smile you have heard those words. I believe that a part of George Washington's farewell address has the answer to that argument. He said,
"If, in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way in which the Constitution designates. But let there be no change by usurpation. For though this, in one instance, may be the instrument of good, it is the customary weapon by which free governments are destroyed. The precedent must always greatly overbalance in permanent evil any particular or transient benefit which the use can at any time yield."
What kind of government did the convention construct? As Benjamin Franklin was leaving the convention hall, he was asked by one of the people outside, "What kind of government did the convention give us?" Franklin replied, "A republic, if you can keep it." I think it would be correct to say that a great many of our U.S. citizens consider our form of government to be a democracy. Most of our school textbooks give that idea to our students. Is there a difference between the governmental concepts of a republic and a democracy? Let's discuss that question. Let there be no misunderstanding. This has nothing to do with the Democratic or Republican political parties, either then or now. There were no political parties by either name at the time of the Constitutional Convention. A democracy and republic have some things in common. First of all, they both involve a government of the people, in which the people have a voice. This is in contrast to a monarchy, dictatorship, or other form of government where all the power lies with one or a few people. Second, they both include adoption of some general democratic principles, such as equality of man under the law, equal opportunity, freedom of speech, freedom of the press, freedom of religion. Why, then, did Benjamin Franklin and the writers of our Constitution call our government a republic instead of a democracy? In what way are they different? And what difference does it make to you and me? There may be people who consider our form of government a democracy, and who at the same time include and agree with the basic ideas of our Founding Fathers. For those people, the words republic and democracy have the same meaning and form, contain the same ideas. Yet, this has led to much confusion. The writers of our Constitution defined a democracy as follows. Democracy, as a form of government, is ruled by majority vote, whether directly by all the people or indirectly through the people's representatives. It has no regard or protection for the moral, civil, personal, or human rights of the individual or a minority. In other words, a democracy is not able to protect the God-given rights of individuals or minorities from the will of the majority, whereas in our constitutionally federated republic, the powers of government are designed and limited so that the God-given rights of everyone are protected both from the will and desire of the majority as well as that majority elected government of the people. What evidence is there for believing that the writers of the Constitution felt this way about the governmental concept of democracy? In the Federalist Papers, James Madison's essay number 10 gives a clue where he says,
"A pure democracy can admit of no cure for the mischiefs of faction. A common passion or interest will in almost every case be felt by a majority of the whole. A communication and concert result from the form of government itself, and there is nothing to check the inducements to sacrifice the weaker party or an obnoxious individual. Hence it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths."
Perhaps it is from this reasoning that Article 4, Section 4 of our U.S. Constitution says,
"The United States shall guarantee to every state in this Union a republican form of government."
That article and section are the same today as the day the Constitution was ratified. Within the republican form of government that the Founding Fathers gave us, many things are to be decided by the democratic simple majority vote process, but certainly not all things. It would seem, then, that the significant difference is that in our republic, an individual's and a minority's basic God-given rights of life, liberty, and property, or pursuit of happiness, are not to be subject to majority vote, but are protected from the majority vote by the very form of government itself. Further, the federal government, made up of representatives of the people by majority vote, was severely limited by the Constitution as to the areas in which it could legally act. Most of the powers of overall government were left to the sovereign states and to the people. So as we consider the governmental forms of republic and democracy, we should avoid any emotional references with the major political parties resembling those words, and concern ourselves only with the basic ideas involved and how they differ. It is the ideas that are important to us, no matter what names various people may give to these ideas. Our Constitution is not a sacred document. It was made by man. It can be changed by man. The Constitution itself, in Article 5, describes the process by which it can be changed. But note that it takes more than a simple majority vote. It takes, in the final stage, a 3/4 vote. So in any proposed change to our Constitution, look you well and long. Make sure that none of your individual God-given rights may be taken away from you or infringed upon in any way. This is perhaps the most precious heritage you will have to pass on to your children and grandchildren. Guard it well. To continue the central theme of our story, the Founding Fathers became aware that the people in the sovereign states were not going to ratify the proposed Constitution unless and until they had further promises and protection against the possible tyrannical power of a stronger federal government. The people were suspicious about the finely worded document. The people said, in effect, "Your words sound fine and your explanations helpful, but we would like, in addition, some very plain, simple words, like our English forebears had in their Bill of Rights, telling us what the government cannot do to us." Here again we see the fears and reservations raised earlier by Rhode Island, a basic distrust of central government. It was a hard-learned and bitter lesson of history they were expressing. The Founding Fathers were understanding and patient. The Bill of Rights for Americans became the first 10 amendments to a Constitution not yet even ratified, as a condition for ratification. Did you know that our American Bill of Rights has a preamble paralleling the preambles of both the Declaration of Independence and the Constitution itself? Not many history books even include it anymore, but you should know how it reads. It helps to gain an understanding of the fears of our forefathers with respect to a strong federal government. The preamble to the Bill of Rights reads as follows.
The conventions of a number of states, having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. And as extending the ground of public confidence in the government will best ensure the beneficent ends of its institutions, be it resolved.
Then followed the first 10 amendments. And so it was by the explanations and urging of many of the convention delegates, plus the promise to the people of the first 10 amendments, the United States Constitution was ratified. Delaware was the first of 3 states to ratify in 1787, with another 8 in 1788, 1 in 1789, and finally Rhode Island in 1790. Rhode Island, you remember, did not send delegates to the convention, and for 3 years refused to ratify the Constitution. Only when the new government began to deal with Rhode Island as a foreign country and impose import duties on Rhode Island exports to other states did Rhode Island bow to the economic pressures and ask for admission by ratification. Today, as in the past, we're being urged to have no fears about our central government, for after all, didn't we, the people, elect that government? A quotation by Thomas Jefferson reflects the thinking of our founding fathers on this subject. He said,
It would be a dangerous delusion were a confidence in the men of our choice to silence our fears for the safety of our rights. That confidence is everywhere the parent of despotism. Free government is founded on jealousy and not in confidence. It is jealousy and not confidence which prescribes limited constitutions to bind down those we are obliged to trust with power. In questions of power, then, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution.
Consider also the words of Patrick Henry on this matter.
I dread the depravity of human nature. I wish to guard against it by proper checks and trust nothing to accident or chance. I will never depend on so slender a protection as the possibility of being represented by virtuous men.
He went on to say,
Show me that age and country where the rights and liberties of the people are placed on the chance of their rulers being good men without a consequent loss of liberty. I say that the loss of that dearest privilege has ever followed with absolute certainty every such mad attempt.
It is interesting to note the parallel between the 10 Commandments of the Bible and the 10 Amendments in our Bill of Rights. Each of them are essentially a grouping of thou shalt not. In the Bible, it is God commanding his people. In the Bill of Rights, it is the people commanding their government. It was understood by the people that a recital of thou shalt nots was necessarily limited. They couldn't list everything they wanted the government to be prohibited from doing. To overcome this problem, they included the 9th and 10th Amendments, which read as follows.
The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
And then, as though to make sure to an even greater degree, they followed with the 10th.
The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
Would you say that the people and their delegates had done a good job in limiting the powers of the federal government, in the body of the Constitution itself, plus the Bill of Rights? In any event, they thought so. If they hadn't, we wouldn't have the Constitution we have today. And so it was that, without shedding a drop of blood, One form of government was abolished, and another was substituted in its place. A first-time event in the pages of history. And for more than a century and a half, the written form of this Constitution has remained essentially unchanged, with but 14 amendments after the original 10.